Hi, I'm Sarah Coach with Alt Legal, and I'm here today with Moish Peltz, who is a partner at Falcon, Rappaport, and Berkman in New York, where he specializes in business and IP law. Moish has joined us today to discuss what IP attorneys need to know about cryptocurrency and NFTs. Moish, thanks so much for joining us today. Let's start with a basic overview of the terms that we'll be discussing. So if you could first tell us, what is cryptocurrency? What are NFTs and what is blockchain?
Hi, Sarah, and thank you so much for having me. And of course, so this subject can be a little bit complicated if you don't already have a context for what these things are. And so it helps to understand each level of what's going on here, and then you can build up your knowledge based on perhaps a more solid foundation. So this technology generally is running on the blockchain. The blockchain is a distributed database where the entire history of these transactions is on this ledger. It's a continuing chain where each block confirms all previous transactions that occurred within this database. So this blockchain is the train tracks, the framework that allows cryptocurrency and then other types of tokens like fungible tokens and non-fungible tokens to exist on top of that technology. So we have on the base layer, the blockchain, and then on top of that are cryptocurrencies, which are being sent, perhaps or transmitted on top of the blockchain, or they're using the blockchain to transact. And then those systems allow different types of tokens. Like a token, for example, a fungible token would be something that exists on top of that layer that can be spent just like a cryptocurrency. So it may be a token might be a type of currency that exists on another blockchain. So for example, the Ethereum blockchain allows all sorts of different tokens to exist on top of it. And then non-fungible tokens, unlike currency, are something which are unique. They can be thought of as things like collectibles, like basketball cards or comic books. Another helpful analogy someone I just heard was that you are the museum, or you own something and you can display your ownership of that collectible. So it's not only the collectible itself, it allows other more complex things to happen on that layer.
Got it. Thank you. So the next question, can you give us some context for why NFTs are relevant for trademark and IP attorneys?
Sure, and I hope that attorneys, if they're not already involved, they've at least heard of some of these ideas and hear that they're becoming more and more common. They have I think the potential to disrupt a lot of existing businesses, especially traditional finance seems like one where the cryptocurrency payments aspect is already kind of nipping at our heels, right? So I think that attorneys, and especially intellectual property attorneys, should be aware of these technologies and understand how they might impact their clients' businesses. On top of that, they to the extent they are representing intellectual property owners, different brands, different content creators, those are people that are going to be wanting to take advantage of these technologies and using these technologies, especially NFTs right now, to find new audiences for their IP, for their brands, expand perhaps the way they connect with those audiences, the ways they connect with those audiences, and ultimately perhaps grow some revenues. So I think for a lot of attorneys, they're going to start seeing that their clients are perceiving these technologies as a huge opportunity for their business.
Absolutely. So our next question is, what are the NFT marketplaces to be aware of and what is being sold?
Yeah, sure. So right now there's a ton of different NFT marketplaces. I think there's different ones that are appearing almost every day at this point. And the idea is that an NFT is something that can be listed. Well, first it can be created, right? It's a digital asset that can be uniquely created and sold, traded, auctioned, right? So then there are marketplaces that are emerging that are allowing people in a more seamless way, without having to understand the underlying technology, to list their NFT for sale, to auction it off, to create some branded collaboration, something like that. So there's public marketplaces, for example, like OpenSea, which are just an open platform which allow people to buy and sell an NFT as if it were on an exchange, right? As if it were on Coinbase, something like that. But instead, it's a visual representation of this NFT, and you can sell it or buy it using typically the cryptocurrency on which the NFT exists on top of. So, OpenSea would be an example of a more open platform that allows anyone to just enter with their wallet and buy and sell. Something like NBA Top Shot would be something that's more of a closed marketplace. This is an officially licensed marketplace that the NBA has partnered to create and allow digital collectibles of videos of NBA plays to be bought and sold as a collectible. And so there's a ton of other platforms that are doing this. A lot of them are trying to add on different elements that are going to be interesting for both buyers and sellers in the marketplace, but also that are going to enable different utility for people that are creating these NFTs. So, for example, if you're a brand owner, you can start thinking about the types of royalties that you're going to be able to collect upon sale. Because those are the different things that make these exciting for my clients, for people that are looking to create NFTs in these marketplaces.
Definitely. So what are the copyright issues that should be considered when creating NFTs? I know we were just discussing royalties.
Sure, absolutely. So I think the real basic question here, from a copyright perspective is, if I'm a brand or an IP owner or a licensee, someone that's going to create an NFT, do I have the right, with whatever grant of IP or IP ownership that I have, to do the use that I'm intending? So I'm looking to create an NFT. Do I have the right to use the copyright that I want in this NFT? If you're just an artist and you made the art yourself, it seems pretty straightforward. Hopefully you should have that right. But I think it starts getting complicated when you have co-authors in the copyright, when you have companies that, I think these issues can be thought of as somewhat traditional, right? It's the question of work for hire. Do I have from my employees the rights that I need to go out into business and do the things that I want to do? Except now it's not, it's a new context, right? It's an NFT. So existing license agreements, existing agreements between you and your employees, existing agreements in other contexts may not have considered NFTs as the ultimate use case for what you might be doing with your copyright. So, the answer might be easy. You just look at the agreement and says, do whatever you want with it and go and do it. But maybe it doesn't say that, right? Maybe it says something more limited. Maybe you got to go back to the copyright creators. Maybe there's other rights besides copyright that you need to execute your strategy correctly. On top of that, there's things like fair use, which, really haven't been analyzed in this context yet. So, those are questions that intellectual property attorneys are going to have to start asking, and we might be answering for a long time, depending on how all this plays out.
Absolutely. So in the same vein, what trademark issues must be considered when creating NFTs?
Yeah, I think it's a similar question as copyright, but just it's going to be a little bit different, right? So it's still, do I have the right to use the trademark in a way? If I'm doing something that's branded, do I have the right to use that trademark in this context of NFTs on these marketplaces, along with the sale of these NFTs? Are there other goods or services that are being packaged with an NFT? If so, do I have the trademark rights to work with those? How does that work? And then I think it gets to, the question of what we're doing with those trademarks. Are there other protections that we need to plan for or predict? Are there other trademark aspects like quality control, things like that we're drafting licenses to consider, things like that. So, I think a lot of the questions here are still open, and the exact check list of what you need to do, I think is still evolving.
Definitely. So next, in terms of actually dealing with a client, when they come to you to secure a trademark or copyright protection over an NFT, what are the steps you need to take? And then the second part of this question, for trademark protection over an NFT, what are the classes you should be searching and filing in?
Sure. So I think for the protections, it's a question of, what are you doing? What's your plan for the NFT? What's your strategy? Are you going out and are you minting your NFT for an existing platform? Are you partnering with someone to create a platform or to do something else with your IP? For example, like the NBA did. So what are the terms of service that are going to govern the creation of your NFT? I think there's different ways to answer that question. Who are you partnering with, right? Because I think that's very important in terms of protecting your IP. Is who are you going to be giving the right to use your IP, and in what context? And is that something that's limited, or is it all encompassing? Is it something that you can take back, an NFT and on the blockchain, maybe an irreversible transaction in some respect. So if you're putting it out there, do you have control over it after the fact? So I think those are the kinds of questions you need to be asking. I think, as with any trademark or copyright use, IP attorneys know we should be thinking about protecting those assets, registering them in national offices, if that's in the US or internationally. We should be looking to protect those assets early, to file and register as early as we can. And then when we get to that second part, for prosecution, I think, as I had in my article, there's a number of different classes that are already being used. I think that those are perhaps somewhat obvious, that you have either downloadable or non-downloadable computer applications for certain cryptocurrency uses. You're providing a cryptocurrency service or a marketplace, so that's going to be, the applications are in classes 9 and 42. The services might be in classes 35 and 36. And there's just examples of what people are already doing there. But I think also the idea as well, if you're also packaging some other service, or you're now combining an NFT like service or a cryptocurrency service with some other traditional business offering that you may have, are your existing trademarks, copyrights enough to protect you? Or are you now going to have to start exploring, new classes, new product lines to, proactively cover the intended use by your client?
Got it. Thank you. So our next question, when engaging in a license agreement involving NFTs, what must be considered?
Yeah, so I think this is really exciting area here, which is, if you own IP, if you're a brand, if you're, what do you need to do to get comfortable in this space and to allow yourself the opportunity to profit off this area, in a safe way where there's guide rails, and I think the license agreement is generally going to be, the way to do that. I mean, to the extent people are going to feel comfortable. So I think, absolutely, to the extent you're entering the space and you're doing so with other people, you need to make sure that those arrangements are considered, are in writing, are binding. That you're considering who are the parties that are authorized to act, and what different hats they're going to wear in these transactions. I think the parties should be considering, which platforms they're going to be operating on, the kinds of NFTs they're going to be creating. One of the really exciting opportunities here is the idea of royalties upon resale. So, for example, Saren, if I sold you an NFT, and then you turned around, so obviously I'm getting the proceeds of that sale, net of whatever fees are involved. But then let's say you turn around and you resell it to Nihal, right? I, as the creator of that NFT, would get a royalty potentially upon your resale of the NFT to some third party, right? So these are things that I think have to be considered at the beginning, at the onset, how these parties are going to handle these royalties, how they're going to handle resale. And then, getting to more traditional license agreement terms of, how's the marketing campaign going to look? Who's getting attribution for certain things? How are disputes going to be handled? Whether there's any risks that need to be predicted, and maybe a party is handling the compliance or risk mitigation factors. So there's a lot of different factors that need to be considered in this area.
Great. And what do you do if someone has infringed your intellectual property in an NFT?
Yeah, so this is a really interesting area, and I'm guessing it's probably going to be a really frustrating area for IP attorneys for a long time. Because of the nature of blockchains and that they're decentralized, open, internationalized, pseudonymous, and that you may not know who the actor or the infringing person is. This has the potential to be very difficult, right? So if you don't know who's infringed your work and where they're located, what are you going to do to stop it, right? So I think, in the context of BitTorrent and other, decentralized internet uses, IP attorneys have already experienced this. I think this is just going to compound that problem. But I think, to the extent that you can identify, who's infringing, where they're located, what platform they're operating on, these are things that attorneys are going to have to counsel their clients on about, how the platforms are able to perhaps execute a takedown, where that's going to be located, and if that's sufficient, or if there's something else that needs to happen, right? Is it just a takedown? Is there some demand letter or perhaps litigation step that can be taken? Again, it's going to be really fact dependent and depend on what's happening. But I think intellectual property attorneys are going to have to know about, or at least know enough about the ecosystem to at least advise their clients as to what the options are and what's practical, what's not, what might be cost effective, what might be just completely impossible to control.
Definitely. And then lastly, what are some of the risks of using NFTs?
Sure. So this area, I think, is something that perhaps might be a little bit outside the scope of what an IP attorney is going to do, but I think everyone should know a little bit enough to at least know that there are potential securities issues here. You're selling something that is essentially unregulated. The SEC and other government regulatory bodies haven't really issued guidance in the context of NFTs. They're relatively new, so it's at this point, I think it's unclear exactly what diligence steps need to be taken. It's unclear whether there's going to be regulatory guidance in this area. So I think attorneys just in general need to be mindful in the cryptocurrency world that the regulatory landscape is shifting, and there's a lot of gray area. So you may want to have someone on call that is perhaps more experienced in the regulatory space here, so that the right questions to ask and can make sure that your clients aren't getting into potential civil and criminal issues based on their minting of NFTs and acting on these platforms, because it can be a potential minefield.
Definitely. Well, thank you so much, Moish. Those are all the questions I have today. We really appreciate you joining us and for your very helpful discussion.
Of course. Thank you so much for having me.